Regarding the Ripple's updated deadlines established in the SEC legal dispute, the lengthy legal dispute between Ripple and the Securities and Exchange Commission, the former is poised to gain steam again as crucial deadlines approach. Litigation has been a constant cause of disruption to the XRP environment, so it is no surprise that the XRP community will be closely monitoring this issue in the hopes that it will finally be resolved. The SEC and Ripple will likely square off again soon. The initial brief for the Securities and Exchange Commission is due on March 22, according to a post by James Fillon, a former federal prosecutor. In contrast, Ripple's response brief is due on April 22. Once that is completed, the SEC will move on to sending its reply brief with a deadline of May 6th. According to Fillon, these dates are now part of the revised timeline for the March 13th opening short submission to the SEC, which will cover the remedies. However, the commission went ahead and asked Judge Annalisa Torres for a 1-week delay, citing good cause as the reason why the application should be approved. Judge Torres approved the request after additional deliberation. Furthermore, the SEC asked that Ripple's opposition brief submission date be rescheduled from April 12 to April 22 rather than April 12. The defendants would have ample opportunity to respond pertinently to the commission's brief if this were to happen. This remedies briefing step follows the discovery stage, which involves the regulator requesting particular papers from the cryptocurrency company. These documents, which contain the institutional sales contract after the complaint, will be the focus of the opening brief that the Securities and Exchange Commission will deliver. Also included in this paper are the Commission's demands about the remedies that should be granted to it in light of Ripple's breach of securities regulations. The cryptocurrency company's institutional sales were deemed investment contracts in a previous order by Judge Torres. Some potential results of the remedies briefing are presented here. It is expected that the Securities and Exchange Commission would seek an injunction to stop Ripple from violating securities regulations through institutional sales, in addition to fining the company. Conversely, the amount of the fine that the commission want to donate to Ripple will likely be the subject of our disagreement. Ripple may also claim that the decentralized loan transactions it facilitates offshore do not constitute securities. A legal expert named John Detton had previously warned that the remedies briefing could end up being more complicated than it seemed, since it was probable that further papers would need to be filed by both parties. After that, Deaton stated that he doesn't think anyone will make a decision until the summer ends. Another potential outcome is that any party may decide to appeal the decision when it is finally handed down. There are new due dates for submitting remedies that the court has on. The updated schedule permits the SEC to submit its opening brief by March 22nd, even though the cryptocurrency industry is still anticipating the gavel to fall and formally end the protracted legal impasse between Ripple and the U.S. Securities and Exchange Commission. According to the court records, defense attorney James Kay has set the deadlines for Ripple's objection in the regulator's response May 6. For your reference, in July of 2023, Fallon shared in his most current report about the Ripple SEC complaint that it was filed on March 14th. In her decision, Judge Annalisa Torres held that whereas Ripple's sales of XRP to institutional buyers constituted sales of securities, the sales to regular consumers did not. So right now, the sides are trying to settle on how much money Ripple should pay in damages. Consider the retail industry's unsung hero is a stock that's been making investors billions of dollars while outperforming the market. It was 13 minutes ago, so that pendulum might be integrated. A new vault for leveraged real-time strategies has been released by Aeroids Finance half a minute ago. What's the big deal with silver and gold? And what gives Robert Kiyosaki his undying devotion to Bitcoin? Bitcoin Frontier Fund announced substantial investments in the Bitcoin ecosystem exactly 1 hour and 19 hours ago. Have a peek. Help us show you one newsletter at a time how cryptocurrency has changed the world. Why are you hesitating? Get daily market and news information sent to your inbox by signing up right now. Join our millions of other subscribers. Sure, a huge number of individuals we approved the SEC's request. Information provided by the former federal prosecutor and reported by Feinbold indicates that the Securities and Exchange Commission had requested the revision to the remedy briefing dates on February 27, as noted earlier. The SEC's reaction, the blockchain industry's pushback, and the agency's opening brief were all part of this revision. As part of their justification for the extension, the regulatory watchdog's legal team cited the fact that there was good cause under the federal norm of civil process. Completing remedies-related finding and briefing is also given the utmost attention. Furthermore, The request mentioned that Ripple has agreed to the SEC to cease petition, even though Ripple was already awarded an extension for the initial discovery date by Magistrate Judge Sarah Netburn. This is due to the fact that Ripple is also implied in the petition to be granted an extra 9 days to file its opening brief. The Securities and Exchange Commission filed a motion to amend the Ripple briefing schedule on March 1. Dylan mentioned in his remarks that the court had approved the petition shortly after. When will the case between Ripple and the SEC conclude? Meanwhile, everyone in the cryptocurrency industry is waiting impatiently for the SEC Ripple case to conclude, and they are keeping a close eye on every RippleSec news article. Given the lengthy legal battle that may ensue, it is probable that the issue will not be resolved until 2026. The court ruled that XRP was not a security when offered to the general public on an exchange, but it is when sold directly to institutional investors, according to a recent report released by the European Corporate Governance Institute. There was already some confusion before this information came out. This note was published by XRP influencer Reth O'Kaneman. In response, lawyer Bill Morgan made the following observation. Unless sold as part of a security investment contract, a token cannot be considered a security on its own. Not only that, but Morgan said that the statement wasn't really helpful. Some people are still being led astray by this, even among XRP community members. The latest development in the long-running legal dispute between Ripple Labs Inc. and the SEC is the announcement of additional due dates for the presentation of corrective briefs. During the protracted legal battle that has garnered widespread interest outside of the cryptocurrency sector as well, the continuing war enters a key new phase with this latest revelation. An important person who has been keeping tabs on the Ripple SEC issue, attorney James K. Fallon, has recently announced a change to the timeline for the remedy briefing. The announcement made by Fallon on X states that the opening brief is due from the Securities and Exchange Commission on March 22nd, and that Ripple is expected to submit its opposing brief on April 22nd. After that, on May 6th, the Securities and Exchange Commission must submit its rebuttal brief in response to Ripple's February request for an extension of time for remedies-related discovery. The latter delay was made possible by the most recent schedule changes. The Ripple native token, XRP, has remained above the 0.62 level despite a recent decline in price. This stability is happening at a time when the XRP ecosystem is seeing a lot of activity, like the Digital Asset Summit and the impending deadline in Ripple and the SEC's legal battle. The forthcoming XRP Gold Coast Conference is the next event on the agenda for XRP holders. Notable speakers at the conference include crypto attorney Bill Morgan and pro-XRP lawyer John Detton. The future of XRP's pricing and community attitude may be revealed by the discussions at this conference. There has been a decrease in the number of active addresses and metrics tracking the supply of XRP on exchanges, according to on-chain data tracker Sentiment. There appears to be less trading activity and a change in market dynamics based on this, but less supply on exchanges usually means less selling pressure, which can help keep prices stable or even go up. So that's all for now.